Thank you for having me here. And the answer is yes. We have been missing the plot for a very long time. And it's a great pity because the solution is very simple. And I'll tell you why we have 4 courts. Actually, there should be more. So I'll tell you why this is the situation. One is arbitration is widely touted as the remedy, which is speedy and which is cheaper. It turns out that it is neither. Right? I don't think anybody who does, for example, infrastructure projects expects arbitration to be cheaper than litigation. In fact, it's probably the other way around. As far as speed is concerned, it might be speedy considering, but that is more a function of the extreme caseload that our courts are now facing, especially after COVID, which is very unfortunate. But it has nothing to do with arbitration being the quicker of the two. The third aspect we forget. The third aspect is that ultimately we call it ADR, but it is actually litigation. All that you do is you're not sitting in a courtroom, you're sitting in a conference room. It is litigation, it is adversarial, and the arbitration tribunal decides huge fortunes. So the third criteria should be that ultimately justice should be done. You may lose the matter, but you should walk away from the matter feeling that yes, okay, well, give or take, I think this was the right award. Okay, you may say, okay, on second thoughts, this was the right finding. Unfortunately, that does not happen. And this is the reason why most awards are challenged in court. And this is a very important issue because if you want arbitration to grow, how do you suppose arbitration will grow? Arbitration in India will grow if people believe that you cannot get the right award, or getting a right award is simply a function of who the arbitrator is. I'm sorry, I'm being very frank here. Okay, and this is the unfortunate truth. And this is something that needs to change. Now, how do we change? One, we need to make sure, first of all, that the arbitration bar says that, look, if you are an arbitrator or if you are a counsel arguing arbitration, you will only do arbitration, you will not litigate. This will mean that arbitration is not a part-time profession. It's not something that you do after 4:30 p.m. This is the reason why most large Indian companies, if you see all large Indian groups, they will opt for arbitration, but they will not opt for India-seated arbitration. They will opt for CAC, LCIA. Why? Because in those institutions, there is certainty, you know the rules. Here you have ad hoc arbitration. So the arbitrators set out the rules, and different arbitration panels have different rules that they follow, even on evidence. I cannot allow this, I will allow this. But there is no certainty. The more important reason is, after the pleadings are complete, arbitration is over in 5 days. It's a very intense process. You start on a Monday, end on a Friday. It is exhausting, but the matter is over. And it is a chess clock. What is a chess clock arbitration? It means that each party can elect, out of the 5 days, the time is divided equally. Now you have 2.5 days to make your case. You can choose how to spend your time, maybe more in evidence, more in opening arguments or closing arguments. Here we do not even have opening arguments, which is a pity, which means that the arbitration panel does not even know the case unless they've read the brief, which is more the exception than the rule. The panel will not even know what the case is all about. So the opening argument, which summarizes the case, is a very useful tool. And it can be finished in 5 days. Here what we try to do is, you see, the other problem is that every lawyer without a brief and his dog has an arbitration institution. There are some very good arbitration institutions. MCIA is one, the Nani Palkhiwala Institute down south is one. They're very, very good. But why do we need so many arbitration institutions? At last count exceeding 30. Right? And I think I was talking to one of the people who did this report. And he said that, well, we can't prevent anybody from setting up a non-profit and say that it's an arbitration institution. So that's the unfortunate problem that we face here. Now we have a amendment, it was already there in the 2019 Act, which says that the institution should be graded. Graded by what? An arbitration council. Now arbitration doesn't need regulation, please. The arbitration council envisaged in the 2019 report, the report that gave rise to the 2019 amendment, was a council made up of experts. I think it was a bad idea, and it has been made worse because the amendment simply said that the arbitration council will comprise of bureaucrats, which is a complete disaster. So it's getting more and more complicated instead of getting simple. The solutions are very simple. It takes 2 or 3 very quick amendments. One amendment that I really recommend is that 34 challenges should not go to the district court. It takes years and years to come out of the district court, despite there being a timeline imposed by the law. So 2 or 3 very quick amendments and you are done. But until then, even large Indian groups will continue to write arbitration clauses. SEAC, LCIA, DIAC, if not Hong Kong.
So on that point, there are around 65,000, I can just pass that on to Ms. Bharati, please. I'm going to have the next question to her. But around 65,000 pending cases regarding arbitration in district courts all across the country, just to kind of put some stat to that very important point you have made there. Ms. Bharati, across to you, and kind of taking in from what Mr. Villamore said about, not being happy with the awards. This is an arbitrator you chose right in the start. There are parties who are choosing this right in the start, that we agree that this person has the expertise to help us find the solution to this problem. So why are so many arbitration awards being challenged in India right now?
So let's start with your first question about what is the plot.
Correct.
The plot why we introduced arbitration in the first place, I think it was because litigation is failing hugely at some point. The courts were overburdened with the number of matters, and therefore we were looking at alternate solutions for this kind of a dispute. That is how we got arbitration in the first place. Now, arbitration is not something new in India.
Yeah.
We have had, dispute resolution in various mechanisms, through settlements, through conciliations, from ages. Your whole concept of Panchayati Raj, I think, emanates from that whole concept. So I think in India, we always had a mindset of having an alternate dispute resolution as a mechanism. It is only over a period of time, I think, that we started approaching courts for resolution of disputes. And we realized that it is not happening, and therefore we again started looking for alternate dispute resolution. Now, in this kind of a scenario, and Percy has touched upon some very interesting anecdotes, and some of these anecdotes before I answer your question. If you look at the entire framework of arbitration in today's time, when you're getting married, you do not start foreseeing your divorce. So when you are drafting the agreement, you are not actually contemplating what is going to happen, what are the kind of scenarios which are going to happen. So most often than not, the clauses that we actually come across in the dispute resolution clauses in the agreements, they are not happily worded to give sufficient clarity. And therefore, when the matter goes to the court under Section 11 for appointment of arbitrator, because we are not able to agree on a common arbitrator, that is where the whole interpretation starts to happen. Then the court will give sufficient number of reasons of why it should not and why it should and who should be the party and all of that. So I think that is one huge plot which gets missed there, because we have not drafted our arbitration clause in the manner in which it should be drafted, and therefore left to the courts to interpret that clause. I think that's one huge plot missed. The second plot where it gets missed is when it goes under Section 9 in interim orders. I think Section 9 we were doing hugely well when it goes to the High Court, but when it goes to the lower court, to explain it to them what exactly the law is, what exactly the intention of the law was, all of that is a different challenge altogether. So I think that is again another issue where the plot is missed. The third where it definitely is missed is Section 34. And I think, and I'm sorry to say that, but in Section 34, we missed the plot right from the district court up to the Supreme Court. We have been giving different interpretations of what is public policy, how is it to be interpreted, how much of an interference should be given to the award, and all of that. So I think the plot is missed at various instances and various sections and provisions of law that has been given. The third thing about now your question of even after you choosing the arbitrator, why are you still challenging the award and raising the question on the quality of the award, is because we are not always choosing the arbitrator ourselves. Most often than not, we are not able to agree on an arbitrator. And that is when we go to the court for appointment of an arbitrator. And unfortunately or fortunately, till date, I think there is a general understanding that if the arbitrator is a retired judge, he will give a fair justice. So we are not looking at dispute resolution, we are looking at justice as a concept. And that is also where the plot is hugely missed. Because if we leave it to the control of the retired judges, which we have been thus far, I think that is where the issue prominently is. Because they are running it like a civil suit with all of the processes that you follow under a civil suit, even now. Then comes the quality of award. Because it has been treated like a civil suit, the award also, in fact, has a certain challenge. And not just that, because the judges are also looking at reappointments, further appointments. So there are nomination biases also that is there in their minds. So when they are looking at a party, they are looking at an opportunity to be reappointed in another arbitration petition. And therefore, that also is a plot which is missed. So I think there are various, reasons why the plot is getting missed.
Yeah.
And I've just touched the tip of the iceberg. There is so much more that we can actually speak about, because the interferences by the courts at different levels is making the whole plot completely gone for a toss.
Yeah, and it's contradictory to the fact that we wanted minimal interruption from the courts. That was the whole point of ADR, right? And just for the audience tuning in and who's going to watch it live as well, we are not here to hate on the process or on the arbitration institutes or arbitrators in India. We know that everyone is working with the intention to make it work, but something's not working. And that's what we're trying to address here. And we're not going to, and I'm thankful to the panelists who have already started out to say we're not going to beat around the bush with this. We're going to answer that question straight. If you can please pass the mic on to Mr. Lumber, please, because from a general counsel perspective, especially, we're talking about arbitrators. How do you choose an arbitrator? Sometimes you don't have a say in it, especially when an institute is already giving you an arbitrator there to say this is your arbitrator for the case. There are situations, especially in international arbitrations, where counsel actually work together with each other, collaborative, to say that, okay, I don't agree with yours, you don't agree with my choice, but here are 10 more, here are 20 more. Let's find an arbitrator who we trust, who has the expertise, whose award we will not challenge. In the end. So, from a GC's perspective, how are you looking at it?
So, first of all. Have we lost the plot? Who's this we?
All of us.
All of us. So generally, when these matters are discussed, we only include lawyers.
Yes.
We do not think about the litigants. So that is generally that we gets missed. And secondly, you said that it is a voluntary process. Now that is a misnomer. This should be clear to everybody, that it is most of the arbitrations which are happening now are not voluntary. So I'll give you an example. The choosing will come later. Let's take, for instance, all statutory arbitrations where the statute provides for arbitration are not voluntary. Second category of arbitrations are, let us take, for instance, where you do not have the bargaining power. Employee-employer relationships, these are not voluntary arbitrations. You will have to sign it on the dotted line. So therefore, these are not voluntary. All government contracts, It will depend upon the mood of the government and the depending upon whether what kind of a cut, copy, paste or a directive or the wisdom prevailed when it was there. If you want a NHAI contract, probably a gas contract or any other contracts, you don't have a choice. So therefore, for somebody to say that I have a choice is absolutely incorrect. Then you say that if justice was quick and the courts did not have 60 cases in a day, will I go to arbitration? So therefore, you have left me with no choice. Courts have failed us. That is why we are looking at an alternative, not a choice. So therefore, the question of choice is absolutely absurd. It is not because of the choice that anybody is doing what they are doing. Secondly, now you come to the fact that what the courts have done. In India, maybe in other parts of the jurisdiction as well, you are saying appointment of an arbitrator. When that choice was given, what was happening? I would say, in my case, Mr. XYZ sitting on my left, who is also my employee, will be a arbitrator. So therefore, the person sitting on the other side does not have a choice. This choice I had till there was Parkinson's judgment. That said that the person who did not have a bargaining power had no choice. Then now you come that okay, there is a balancing factor. If I choose one, you choose one, and the third one is chosen by the two, then there is a choice because there is a the person interested in the subject matter of the dispute has a choice. Once I go in section 11, you are saying 60,000 cases, out of which are section 11 cases where there is a Urdu couplet which I don't remember. दो ही वक्त याद हैं, एक तेरे आने से पहले और एक तेरे जाने के बाद. In between is something which has happened. So there is in between, there is arbitration. Before that you have a notice, you have a section 9, you have a section 11. And then after that you have again section 9, probably you have a section 34, 37, and then you go to the SLP. So the world is not a matter of choice. If somebody is saying that there is a free will and you have a choice, in section 11, this question went up to the Supreme Court twice. And the larger bench seems to have settled it that whether the appointment of an arbitrator is an administrative or a judicial decision. They have not been able to resolve this till date. Is there any application of mind required? If it is an administrative decision, then why should it be with the Supreme Court? Right. So even if it is a decision on the administrative side, then what is the criteria? How are the judges appointing arbitrators? Do I have a choice? Why does an arbitrator always get appointed 10 kilometers from the radius from the High Court alone? So therefore, the jurisdiction of intellect certainly exceeds more than 10 kilometers from the High Court. So there is no matter of choice. So what happens if we are going to have a sole arbitrator in a matter? Then we leave it to the choice of the institution or the courts to decide, because we cannot decide at that given point of time. So the point is that if you are saying that arbitration is completely a matter of choice, and I sitting over here as a general counsel or while drafting the agreement, I'm going to make that choice. My law firm is going to be there, the other side is going to be there, my management is going to be there, and the system. So ultimately what I will do is, rather than bringing certainty to the entire thing, I will bring an uncertainty and say that the institution will appoint, or let the High Court break its head when the occasion comes.
Yeah.
So therefore there has to be some method to the madness insofar as the statutory process of appointment is concerned. This process of appointment itself, if you leave it to the parties, we have seen what has happened. And if you leave it to the judges, you know what had happened. And once you leave it to the institutions, 5 years down the line, you will see that what has happened. So we will have to devise a mechanism, and I have been always propagating that if there are no specific qualifications which have been done, then let AI appoint an arbitrator. The process will be faster and more fairer.
Right. I think that's a topic the next panel can surely take up, because I know they're dealing with AI. Can I pass it on to Can I pass it on to Ms. Chawla, please, for the next one? I just want to bring in this, once again, coming back to this point, are we missing the plot with ADR? And thanks for that really important insight there, Mr. Lamba, about the voluntariness of it, because you can argue both ways on it, but I see your point in terms of there is no choice, especially in these kind of situations that you have just described. Ma'am, from your side, what's been your perspective on this? Are we missing the plot?
Okay, first, thank you to Vidhi for having me here. Before I get to the answer, I see a lot of young people, and thank you for being here. Just a show of hands, how many people are familiar with the concept of arbitration and the difference between arbitration and mediation? Does everyone want me to give a quick overview of what is arbitration before we get into the nuanced issues? So, arbitration, think about it like a litigation. Except that in an arbitration, you don't actually go to court, but the parties jointly in a contract, and essentially commercial contracts. When two parties are contracting, they can pick arbitration and say we will have an adversarial process, which will be a closed room process. We'll go to like a conference room, and we won't go to court. With that preface, I'm a huge, it's a self-coined term, but I'm a huge arbitrophile, where I'm a huge believer in arbitration. And I do believe that since the 2015 amendments came about to the 1996 Arbitration Act, I believe that it has been a huge success. Is everything okay with our arbitration system? Obviously not. But I think we've done a pretty good job. I think most private parties would want to arbitrate. It is faster. There is minimal judicial interference. And what do I mean by that? When two parties go to court, you have something, parties must have the avenue to go to an appeal. Should they or should they not? Because you must, till the time a party is fully satisfied, and that could be till the highest court, you should be able to fight your cause. And that, as it's the right of every litigant. It should also be similarly the right of anybody who chooses arbitration. But remember, when you choose arbitration, the very first leg, which is what we call a trial in court, that is faster. I have the opportunity to sit as a director on the Nani Palkiwala Arbitration Center, which Percy had mentioned. Our arbitration center, which is an institute, the average time taken for every arbitration is 10 months. Now, that may not be everybody's experience. Now, once the parties go up in what we call a 34 action, it's an objection, but let's, for ease of everyone's understanding, let's call it an appeal process. The power of the court to intervene in an appeal in arbitration is way less than it is in a litigation, which is what we call a first appeal, which is a full review of the facts and a full review of the law. The grounds in which a court can intervene in an arbitration, arbitral award, are much more narrow. So to that extent, it's better. Because the arbitration takes place in a closed room, the formality is less. You don't have the rigors of the same court procedure. There is more confidentiality. The arbitrators in most cases are equipped to deal with evidence in a faster manner. Now, is everybody happy with this? The answer is no, particularly the government, because the government's past experiences have been that the awards have not gone favorably in our favor. Now, whether that is a perception or there is evidence to back that up, we simply don't know. But at the end of the day, that is the government's experience, and we should respect that. But I also think we should not be quick to denounce arbitration, because it is, in my opinion, we are just, the 2015 amendments are about 10 years old. We are looking at, the courts are looking at it, the legislature is looking at it very carefully, and those sort of, I think the misses that we have, those will get fixed in the future. I remain very optimistic.
Thank you for bringing that optimistic view, Ms. Chawla. I really appreciate that. If you can please pass on the mic to Mr. Barik. I was just trying to do some research on this. One of the many reasons that parties do run back to court, it's either for the appointment of the arbitrator, or it's about challenging the award, but also to get an interim relief. Especially from your perspective, once again, from head of legal at Gale, your experiences, if you can just answer that, the bigger question of, are we missing the plot with ADR in arbitration specifically, and also whether you've had any experiences in terms of the interim relief measures?
Thank you very much for making me part of this distinguished panel. I must say that with a positive note, because where she has left, because India is progressing, is the 5th largest economy in the world. So, and the kind of progress we have made since 2015 after the amendments have taken place, we have on the right path. So I must say that the question should have been whether we are missing the plot. It should have been how best we can reach to that goal which we have set for ourselves. I think the amendments which have been proposed in 2024 bill which is now comments were invited, and it is now further discussion would be going on. That itself, it is taking care of many of the issues which we have now discussed. Why there is a delay, how to lessen the court intervention as far as arbitration is concerned. As rightly said, that it is an adversarial procedure. So if we expect that the other party would not contest in case the award goes against it, it is something I think not acceptable, because everybody wants that the justice should be done to him. When it is not, that is why it is different to the negotiation or any settlement risk. There is no settlement in arbitration. It's an award passed after appreciation of evidence is produced. So if I have a right to contest if at all the award has not gone in my favor, and therefore, as I said, I agree with her that going forward, and I think we can improve, and we are not missing the plot. We are a bit delayed, and we are approaching on the right direction.
I like that. I like that. We're not missing the plot, but we are a bit delayed in implementing that plot. That's a nice way to wrap up this question, actually. We're saying that it is not exactly cheaper for most of us who have really gone into arbitration. We know it's not cheaper. It's not really quicker. I know Ms. Chawla has put out some very interesting stats there from the center that she's worked with, but a strong majority would disagree with saying that it is not really as quick or as efficient, rather. The right word is as time efficient as it would like to be. Yes, you want to...
Just to add to the time efficiency,
Yeah.
I did some research to understand the data. So an average litigation in India takes about 5 years. And an average arbitration in India takes about 4.5 years. So that is the expediency that we are talking about.
That's a very small...
All average statistics.
That's a very small gap. I want to wrap up this this part of the panel on the arbitration, but by asking you a very provocative question, and anyone can answer it. But do you trust arbitration institutes and arbitrators in India on the whole? Do you actually trust the resources we have here? And I'm basing this on a very important fact that we all know, especially in high-stake commercial disputes, we're either running to Singapore or to Hong Kong or to Paris or to London or to New York. So, question to anyone who would like to answer, do we trust the arbitrators and arbitration institutes here? Yes, sir.
So I'll answer. See, I'll tell you with an example. Why do people want to go to London? So there was an agreement, a law firm was negotiating with the other side, and they were, the big discussion was whether on the jurisdiction, whether it should be London or should be India. So the law firm was arguing that it should be, why should it not be in India and why should it be in London? The promoter came and said that this is not arguable, let's have it London. And do you know why?
Sorry, I missed the last bit.
The promoter of the company came and he says that it was with respect to a hotel, and he says that I'm having a 20-year-old contract and my children will inherit it and I want to go to London. Because what happens is that every year, either we change the law or the interpretation thereof. So you have the choice, you can have your own arbitrators. Once you have had it, spend 3 years, and they say that insofar as that is bad. What will happen to there where it isn't appointed? Today they are saying if one you appoint, one he appoints, third one is appointed, it is good and kosher. 2 years down the line, you will say that that same principle, that the person having interest in the subject matter of the outcome of that thing, today anybody you ask, anybody including the judicials, they will say that this process is kosher. And believe you me, 5 years down the line, we will be discussing over here when some judge will say this is utter nonsense. Then you say that 34, you should have the right to appeal. There is nothing such as appeal insofar as the arbitration award is concerned. The matter is reserved. You can only go for setting aside of the award. You can't go for appeal. So tomorrow what is going to happen insofar as a particular interpretation is concerned, we don't know. And this uncertainty with respect to the law is concerned, that is not going to change by just copying, pasting the law which is in either in Singapore or in UK.
Yeah.
Our judicial system, our ingenuity will fail it. And people are not going because to Singapore that they are better, because the people other side, when they say you have a choice, you have left us with no choice because you have taken away one of the attributes of law, which is certainty from this country. That is why. Otherwise, there is no difference. Why people are going? That even at least there is some certainty. Otherwise, it's a judicial process in India which is so long that I'll just give an example. Sorry, I'm taking a little more time than necessary. Day before yesterday, we got an arbitrator appointed after 5 years.
Wow.
Section 11, Punjab and Haryana High Court. The arbitration will take another 3 years. It will go to the lower court at 34, digressing and little bit disagreeing with Percy. It will take 2 years in Gurgaon lower court and little less or more than 6 years in the Punjab and Haryana High Court. So 34 sitting in Delhi would be very fine. But if but we can ignore if it is dismissed on Friday or a Monday saying that why should we interfere in an arbitration matter? And that is how the justice is going to be done. So ultimately it is not a matter of choice. And then I have not come to the execution. By that time the matter will be in IBC.
Yeah.
And therefore if you are an unsecured creditor, you will be at the last. And this is exactly what has happened with the 3 arbitration awards that I have had, and I can do nothing with them. So while people choose to go to London or Singapore is nothing to do with much with insofar as the institutions over here is, your matter will not see the light of the day till you are on your active life.
Yeah. So the time efficiency is crucial there, and
certainty.
Yeah, and certainty. Yes, the uncertainty hovering around.
I don't know whether a partial award can be set aside, whether modification can happen, whether the one arbitrator that I have appointed, that will still hold true 5 years hence the line. I don't know.
So anything beyond uncertainty that's pushing people outside India to get relief?
Just to give you an example, and that is why I was holding the mic for so long and waiting for Manishji to finish hers. There is an arbitration award that I have, say, about 150 crores.
Okay.
I got the award 2 years back. It was challenged. It was challenged in Delhi High Court. That 34 no interim order has been passed, and therefore execution can continue. I go before the execution court and say this execution is in Ahmedabad. Now in Ahmedabad, when I file for execution, the executing court actually gives me a relief. It directs the party to provide for the list of assets. The party goes and challenges it before the Gujarat High Court. The order passed by the executing court. Now the Gujarat High Court has actually stayed the execution proceedings in a 227 petition. So where are we taking the entire plot is what we need to understand. If the judicial interference continues in this manner, even after having an award and no stay on the award under 34, if we still are fighting with respect to, and what is the issue? The important is the issue that is before the Gujarat High Court to examine is whether Ahmedabad will have jurisdiction because there are the registered office of the company is in Ahmedabad, or the assets of the company is, there is no asset of the company in Delhi, but because the seat of arbitration was in Delhi, so whether the enforcement should have been filed in Delhi. So this is the issue which is being examined by the Gujarat High Court in today's time. This is an issue which was settled by Supreme Court in 2018. But then there are different high courts even then coming up with different interpretations. So I think the point that we are trying to, and I think Manishji also mentioned about it, Percy also mentioned about it, and I think Payal and Deepakji also touched upon, is the interference of the court. It is most important to keep the court's hand off, and for some reason, courts love to interfere in arbitration in some manner or the other. It becomes a favorite subject. Supreme Court decides on whether the agreement should have stamp duty or not. The Supreme Court decides on who the parties to the arbitration will be. So I think there are multiple issues that Supreme Court loves to interfere, and not just Supreme Court. I think it would be unfair for me to say that. Courts generally love to interfere in arbitrations for some reason or the other.
Can I just summarize
Sure.
the situation? So, I agree that in arbitration there should not be court interference, but you must understand that court interference is not the same thing as the right of a party to challenge the award. So if we come back to the first question that was posed, have we lost the plot? I think you are asking the wrong question. The real question to it, the nub of the green is this. Why is it that Indian arbitration panels churn out awards that are not worth the paper that they are written on? I think that's the issue. Now, look, I'm not a fan of 34 because I think it's a very limited procedure available, but there are some people who are saying that the patent illegality argument should be taken away. No, absolutely not. Because you are not giving credence to the third criteria. Why is it that people who have disputes, what do they consider when making a decision about whether court or arbitration, and if arbitration, then whether in India or not? Time, cost, and the likelihood of getting a fair decision. It may not be to your liking. You may lose. But if you believe that, yes, I think the process was fair and what the award says, I can live with it. I think people will go to arbitration in India. Now, why are people not going? Because the quality of the Indian awards is pathetic. I'm not going to mince any words.
Yeah.
Right? It is bad. Now, why does this happen? And how can you prevent it? You are not going to prevent it by having a bureaucrat panel review institutions, or you're not going to prevent it by having an extra body which is only going to create more confusion.
But see, there is one more thing which you must, as a societal, rather than saying, we are very bad losers. We don't accept defeat. मतलब मेरे पिछले जन्मों का कर्म होगा, मैंने कुछ नहीं किया. I have done nothing. We are very bad losers. We don't accept defeat till we go to the Supreme Court. I will not accept any defeat till I am in my employment.
Yeah, so there is that angle. So just to finish, I understand what he's saying. I think I was just coming to this point, which is that the responsibility also lies with the bar.
Yeah.
The responsibility is also with the bar. So if you believe that you're an arbitration counsel, stop doing litigation. I must admit that I am one of those who will not. All right, because the law enables me to traverse both shores. So why not, right? And I will have a very tough time deciding if the law were to say that you can either do arbitration or litigation. I'll have a very tough time in deciding where I belong. But ultimately the solution is stop doing other work, have full day arbitration. That's one. As far as awards are concerned, I must tell you, so there was I'm right now doing a 34. The sole arbitrator who has written the award has been an eminent jurist. In my opinion, if I meet that gentleman, I will touch his feet because I think he has authored some extraordinary judgments. Now, when I read this award, it is horrendous. For example, it says, this notification is a statutory notification. This notification has not been proved by either party. Since when do you need statutory notifications to be proved? And I'm looking at, my God, is this written by the same man? I don't know. So what happens to our judges once they come down from the bar, from the bench? I don't know. All right? And this is an unfathomable issue. I know that gentleman to be completely top class, completely incorruptible, and this is either just a slip or it's there. Now, should the parties suffer because of it? No. Because I'm going to go to the 34 court and explain that, look, this is wrong, obviously. I need hardly say anything more. And because of this, what turns? That's it. So I need the right to challenge the award. Right? I, meaning I on behalf of my clients.
Yeah.
Right? Now, on time, I think you must understand that the market in India.
Mr. Bilimore, I'm so sorry, I need to interrupt you because we have literally 2 minutes. I got a slip here that says we got to wrap up.
Okay, just 30
Yes.
seconds. We have very small ticket arbitration, and then we have very big ticket arbitration, which is infrastructure arbitration. Now, infrastructure arbitration, the stakes are very high. And some of my clients, offshore clients who are involved in arbitration with mostly Indian PSUs say, oh my God, I only have 1 year. I said, no, you have 1.5. But even that's too less. Because infrastructure arbitration, I have some 12 brief backs. So it's not a joke. It is a full-time occupation, right? But it is very intensive. And we have a one-size-fits-all Section 29A that says this should be the time. SIAC and the Singaporeans and Londoners laugh at it, balk at it. So everything is not as it seems it is. And there's just one more thing. The bar also needs to be trained. Okay? I was recently up before a very eminent 3-judge retired Supreme Court panel doing an infrastructure arbitration. There were some 1,500 documents. 3 days before the cross-examination, I'm engaged. And I said, but there's no time. They said, okay, we'll sit with you till kingdom come. Where is the date-wise compilation? We'll give it to you tomorrow. The tomorrow never came. And I got very angry because I said, how could you put me in this position? How am I to do a cross-examination without a date-wise compilation? And this is not some Johnny-come-lately firm. Right? So there is a little fault on the part of the bar also. Also in terms of what Manish said. Manish said that, look, at the end of the day, we are litigants. I do believe that as a society, at least compared to America, we are probably even more litigious than Americans. But it is, for the small ticket arbitration, it is the bar's responsibility to tell the client that, listen, you are not going to succeed.
Yeah, and I think I just want to, Mr. Bilimore, if I can just wrap up with that, because I think we want to kind of have a bottom line to this, and there is accountability, right? We are not on track, it's for sure. We have not missed the plot, but we're not on track either, and there's a delay in that implementation. There is accountability that needs to be there from both the bar and the bench. We need accountability from the arbitrators, we need accountability from the council, we need accountability from institutions. I need to borrow exactly 5 minutes from the organizers because mediation is my baby child, and I want to steal 5 minutes from everything that's going to come on now for a quick and please a 45-second response each. I beg you, because we are not going to get through this, for telling me if we are missing the plot with mediation as well. Let me be more specific. How can lawyers, because I think we have forgotten about the lawyers in this whole mediation space. We have a law now which is around 17 months old. It's like a bastard child sitting there. Nothing has happened. We have not had a mediation council of India formed. It's just lying there. Everyone got excited about it in September 2023, and nothing's happened. So nothing will happen either. So if we have to take mediation forward, especially in the commercial dispute space, I feel we need to put the focus back on the lawyers. It's the lawyers who will drive it through, not the law. And so as lawyers, how can we get back on the track in terms of getting mediation to serve the purpose of ADR? So quick question to all our panelists. So
30 seconds.
Yes.
I think there's a very big flaw which says that prior to institution of a suit, there must be mediation. That is the wrong moment of time. In commercial suits, prior to a suit, the dispute is just ripe. There are sometimes frayed egos on the part of the client. You are not going to have a settlement at that time. Also, mediation is often misused by the lawyers. When they believe they are up before a judge who is not in favor of the case they are presenting, they will say, please send it to mediation, and the bench will be very happy to do that. Because right now the current belief is, if something is getting mediated, let it happen. And so it is grossly misused, it's not workable. The best time for mediation is when the matter is mature, let's say after evidence, when one or the other parties realizes that, look, if I don't settle, I may lose this. That is the opportune time.
Yeah, that case has to be ripe for mediation. Thanks for bringing on that point about when to mediate. Ms. Chawla, to you.
So I agree with Percy. I don't think mediation can be forced. My only point of difference would be that I wouldn't blame the lawyer or the client. It's just a question of, finding that right moment in a litigation, and that you can only know when the litigation is there. The only thing is that oftentimes when the litigation is going well for a party, at that time the party that thinks that they're winning is diffident to pursue mediation, and the party that thinks that they are about to lose will be keen to do it. But in litigations, my past 30 years experience tells me it's not linear. And there will be times when one side is doing better than the other. You have to, as litigants as well as lawyers, find that right opportunity and open dialogue, even at the time when you may be doing really well, maybe a time to open the dialogue to be able to get the best outcome for your client.
All right. Ms. Bharti, from your experience, I want to kind of put you on the spot. Do you see scope for pre-litigation mediation at all right now?
Yeah, so I think there are different kinds of matters which has to be dealt differently. Not all, one size fits all is not something that we should actually focus on. So there are certain kinds of matters where pre-litigation mediation works. But in most cases, and in fact in one of the matters that we had in Delhi High Court, and we requested the court for mediation, and the court said, let the parties lose the steam for some time. They are at the moment at the verge of too much of agitation on both the sides. There is no question of going for mediation. It will not really serve the purpose. So I think litigation fatigue is important for the parties to approach mediation, and therefore I totally agree with both my previous speakers that mediation will be successful, can be successful only when it is approached at the right time. And that right time is very important. Pre-litigation mediation in all cases, I think we have seen it, what has happened with the Commercial Courts Act. Most of the time we have a non-starter report in those cases, and therefore the matter ultimately goes to the court.
Yeah.
I think it is at different stages where we should introduce mediation, because once you're tired with litigation is when you would want to explore mediation, and I think that is when it will be successful. Most times, and I think outside of India, they have been doing it after the pleadings are complete, because then also you are able to gauge where you stand in terms of the documents that you have. So I think that is what.
So once again, timing very crucial, and every case is has to be dissected on a case-to-case basis. Mr. Lamba?
See, mediation, pre-litigation mediation is used as wasting other person's time more often than not. And as Percy rightly has said, that it serves no value. See, mediation becomes very, very successful when both the parties know what their position are, or one is tired and frustrated, which happens in most of the civil suits which are there. So they tire and they see the frugality and they get frustrated in the court process. That is the exact time when you see that the matters will get settled. Otherwise, that any commercial suit, you have to have some kind of a mediation before that, is an absolute, in most of the cases, waste of time. I'll just give you a very small anecdote in what happened in a very large organizations, and I can name one. On the other side was IBM. I was dealing with, and we had $1 billion contract. And both sides agreed, and in the management agreed, that if there is a dispute, it is an ongoing contract, otherwise your telecom systems will come down. And they said that if there is a dispute at a ground level, then it will go to the area manager, from there to the general manager, and then at the level of the directors. If it can't get settled there, it will not. Once the dispute has arisen and the notices have been shot, then you say, we will see what the court does. So I think this is a very good point. We don't mediate.
Yeah.
Shri Krishna was not able to do it, nor was in Ramayana we were successful. It is only after the much blood has been lost that we find sense in peace.
I completely appreciate the point about timing. I absolutely appreciate it, especially when we talk about it as in terms of resolution fatigue, decision-making fatigue, when the parties have experienced it all and now they're tired of it, and then you introduce it.
I don't know the full facts. See, at the max state, husband-wife fighting corporate.
1 year. It took them 1 year.
1 year, and then coming to a conclusion that ultimately they will get nothing out of it.
Yeah.
And to save something, they would have entered into a settlement. I read it on your blog only, your LinkedIn.
Yeah, and it's also because I completely agree on the fact that the timing is important. Sometimes when the parties are frustrated, you introduce mediation. But having said that, I've been part of pre-litigation mediations with family business disputes that run into crores of rupees, who tried mediation, sorted it out over 6-7 months instead of getting it into a courtroom situation. Once again, not all cases can be mediated in pre-litigation stages. Mr. Barik, the last word to you.
Thank you. I think mediation was very much there in our country just because the 23 Act has come and
Correct.
we started thinking about mediation. That is in a different form, it is there. If GAIL has got a very good policy of conciliation where we have a success rate of more than 75%. So therefore, we cannot say that we have ignored, we have to not having that success, desired success from the mediation. And banks have got, even if you see the banking sector, a lot of one-time settlements are happening. This is just because of mediation. So,
Yes.
So we cannot have a pessimistic approach to whatever is being done. We should be always optimistic and see that this mediation at right time it is approached. I think that will yield a good result.
Perfect. So on that note, the big question, are we missing the plot with ADR, arbitration and mediation? Are we? I don't know, but I think it's safe to say that we have the plot. We have the plot. We are still plowing the fields, and it will work. So let's remain optimistic. There are stakeholders on different levels: policy, judiciary, the institutions, the neutrals, are all working to make sure we are on the right track. Thank you so much to our fantastic panelists, and thank you for being a great audience. Thank you very much.
A last remark. Our judiciary has to treat themselves as service providers. They should deliver the service rather than deliver the judgments. That's what should be the mood.
Perfect. Yes.
We are going to start a very interesting session on the legal tech in hall number 2 shortly. And those of you who are interested in what is happening, what kind of innovations are happening in the technology space, in the law firms, in the in-house departments, and career opportunities which are techno-legal and the kinds. So you can join us in hall 2. Thank you. We'll be starting in 5 minutes.
इन्हीं का सेशन। अच्छा, इनका है, ठीक है।